Having to take a medical leave of absence. Some are short, but depending on the injury or illness, a leave can be extended. But what rights do workers have before and after those leaves? Employment lawyer Alex Lucifero joins us now to talk more about this. Alex, first of all, let's talk about, many people concerned when they have to do this because of an illness or injury. Can an employee be punished or fired for doing something like this?
Absolutely not, Matt. Unequivocally, an employer cannot punish or fire an employee for having to take a medical leave of absence. It's simply not allowed. It's discrimination on the basis of our human rights code, and it's also contrary to our employment standards legislation in Ontario. And it's important to note, Matt, this is regardless of where the injury takes place. So we could be talking about an illness or an injury that is a result of the workplace in and of itself, or of an illness or injury that happens outside of the workplace, at home, etc. Either way, Matt, an employer has to respect an employee taking a medical leave of absence, of course, as long as there's some medical evidence there from a treating physician.
Right. And again, the medical evidence is certainly part of that. Do people need to do anything if they're off on a leave? Do they have to be doing anything to ensure their job security, or what obligations do they have?
There isn't much of an obligation on the employers or on the employees rather part, except for what we just mentioned, which is ideally you should be providing your employer with some form of proof. And this could be a very basic doctor's note confirming that you're unable to work for medical reasons. That's really the extent of the employee's obligation, Matt. As long as you provide a doctor's note to your employer confirming you're not able to work, that's the extent of your duties. Of course, if your medical leave is going to be very prolonged, so if you're going to be off for many, many months or potentially even years, which would be completely legitimate, you should be providing updated prognosis, updated records every so often, confirming your continued inability to work.
And then on the other side, too, for employers, too, once an employee is cleared to return to work, whether that's through disability insurance providers or otherwise, what goes through that process?
Yeah, so this is often times a situation where things get a little tricky for the employer, Matt, because they have an actual very clear legal obligation to allow that employee to return back to work once they're cleared by their doctor. And the requirements are very specific in that the employer has to allow them to return back to the same conditions of employment they left. Same position, same pay, same terms of employment, same schedule, etc. And that is a very strict requirement. An employer cannot change an employee's position or delay their return back to work, even if the employee is returning with some sort of accommodation. Perhaps they can't work a certain amount of hours, or they can't do certain types of activity. The employer still has to play ball, and play ball to a very large degree. Otherwise, again, that might be a failure to accommodate, and that might be discrimination under the Human Rights Code in Ontario.
We've seen a number of leaves like this, especially over the last 2 years. Some more good information. Alex Lucifero, appreciate this as always. Thank you, sir.
Thanks, Matt. Happy holidays.